Hi, I'm John Wagner Givens, and today I'm going to be talking about non-state actors in international law. So, a non-state actor, most simply put, is essentially anything in international law or international relations more broadly that is not a state actor. Most typically, state actors are very easy to recognize. So, the United States of America, the People's Republic of China, Independent and Sovereign Republic of Kiribati, any country is generally considered a state actor. But this is not always so black and white. So sometimes state actors, the line between state actors and non-state actors could be relatively blurry. So a really great example from history is the East India Company. You can see their flag there on the slide that looks like the flag of a country, and indeed the East India Company had most of the things we associate with countries. It had its own courts, it had its own military, it controlled its own territory, and yet it was actually nominally at least a private company. But this blurring of lines between state and non-state actors is even true today and can cause problems for international law. So we can think about things like unrecognized states, the Islamic State, civil wars in which different countries claim to be the legitimate government of a country. Independence movements create similar circumstances. There also can be private entities representing states. For example, mercenaries or military contractors like Blackwater, now called Academy. Intergovernmental organizations are generally considered closer to state actors, but again can walk this boundary. So these are intergovernmental organizations are formed by treaties between states, and so these are things like the United Nations, the Organization of American States, or NATO, or the WHO. Because these are simply the direct creation of states, we generally consider these state actors, but they can also, again, blur this boundary and work with non-state actors quite commonly. So, like states, non-state actors can play an important role in international law. They do not have sovereignty, and they generally don't have the same power and resources as states, or do they? Usually they don't, but as we'll see in some cases they do. This picture is from the TV show Archer, and Archer in the TV show, which I enjoy very much, and has a lot of overlap with international relations and law, although of course it's a comedy and not to be taken seriously. Archer works for the International Secret Intelligence Service, which is supposed to be a private intelligence agency, so a non-state actor, but again fulfilling the role that state actors might. So we're going to cover a number of different non-state actors today. These are going to include individuals, multinational corporations, international media agencies, non-governmental organizations, violent non-state actors, expert and epistemic communities, transnational networks and coalitions, and social movements. So before 1945, international law rarely recognizes individuals. Except in limited specific cases like in piracy, a specific international crime. And even then, it usually only recognizes individuals as subjects of international law. So you violated international law and then you can be punished, but it doesn't recognize you as saying having the ability to influence international law or having certain rights under international law. But the UN Charter after World War II calls upon member states to observe human rights and fundamental freedoms for individuals. This is obviously a response to war crimes and crimes against humanity committed during World War II. So individuals generally lack the standing to assert violations of treaties. So if you violate a treaty, usually you can't bring, say, a country that has wronged you under international law to court, but some treaties increasingly do allow individuals to have direct access to international courts and tribunals and challenge the actions of other states or non-state actors. Yet increasingly, particularly powerful individuals can influence international law. They can't sign treaties, of course, but many individuals now have the net worth of at least small countries and are capable of influencing international law. This is George Soros. He's a well-known financier. There are a lot of crazy conspiracy theories about George Soros. I urge you not to believe them. However, George Soros is an excellent example of perhaps fact being stranger than fiction, or at least more interesting. In 1992, George Soros decided, he was a currency trader, and he decided that the British pound was overvalued. He started a run on the British pound, short selling the British pound. In other currency traders agreed with him and also started short selling the British pound. Eventually, the United Kingdom was no longer able to defend or keep the price up of the British pound. It was forced out of the European exchange rate mechanism, and this resulted in the British pound not being part of the euro. So as we can see, George Soros here had a tremendous influence on international finance, and actually was able to essentially overrule something the government of a sovereign nation wanted, which was to join the euro, because of his influence in international financial markets. George Soros made $1 billion from this. He's now said that he regrets it. But again, these individuals, especially particularly wealthy or otherwise influential individuals, can have a huge influence on international relations, international law, and international relations in general. International media agencies are not commonly thought of as important actors in international law or international relations, but they do have kind of a special place and a role to play. And this is because they inform us about the things that are happening around the world. They have the ability to control and shape information and narratives. And so this means that, like sovereign countries, they can control what people think, and indeed control what people think about countries, right? So if President Putin or President Xi or President Joe Biden tells you something about Russia or the United States or China, a international news agency might contradict that, and that might change the way that you in particular, or people more broadly, think about an international issue. Therefore, it may have an impact on international law. And so it's worth thinking about these in their own special category, even though in a lot of ways they will successfully also fit into another category, such as a multinational corporation or a part of a nation state. So some examples of these are the French press agency, the oldest international news agency in the world, the Associated Press, Reuters, Xinhua, which is the Chinese news agency, are all useful examples. Multinational corporations are increasingly some of the most important actors on the world stage commercially, in terms of international relations and especially international law. Multinational corporations, put most simply, are companies that operate in more than one country, and there are around 100,000 MNCs in the world today. But there's a governance gap that from the absence of corporate regulation that can limit multinational corporations under international law. This comes from the fact that although it is primarily domestic law that applies to multinational corporations, countries compete for MNCs to invest in them, and therefore they tend to lower their regulation to try to attract MNCs. It also comes from the fact that if MNCs don't like the law in a particular jurisdiction, if they don't like the domestic law in one place, they don't like the tax code, for example, they can shop around and find another country that's willing to offer them something more attractive. So over time, the regulation of MNCs has tended to weaken rather than strengthen, and this has also coincided with MNCs generally becoming larger, wealthier, more influential, and controlling more and more of the world's economy. So in many ways, MNCs are the largest and most meaningful threat to the dominance of sovereign nation states in the world today. And if you don't believe me, take a look here at these numbers, comparing the largest multinational corporations and countries by revenue. So as you can see, the largest countries in the world, like the United States, China, and Germany, have much more significant revenue than even the largest companies in the world, like Walmart, Sinopec, or Amazon. Once you start getting down the list to countries like Mexico, Belgium, Sweden, Poland, and Switzerland, which are only which are still top 20 countries in the world in terms of revenue. These are countries that actually have smaller revenue than some of the biggest companies in the world, companies like Walmart, right? So Walmart has over twice the revenue of Switzerland. This means that MNCs are often not outgunned in terms of wealth and resources. They're often not outgunned by even relatively large and wealthy countries, never mind much smaller countries. Now, they are outgunned generally, literally in terms of military. Most companies do not have many of the other resources of nation states, but I still think this goes to show how multinational corporations are increasingly important on the world stage. So, we finally gotten to non-governmental organizations, or NGOs. NGOs are what people often think about when they think about non-state actors in international relations or in international law. We often tend to think of them as the most common types of non-state actors, but I want you to consider whether or not that is really true. Now, of course, it would depend how we define that, but think about some of the other non-state actors we've seen and the other non-state actors we're going to see. Keep in mind whether NGOs are really the central or dominant non-state actor in international law. So NGOs are voluntary organizations. People join them, generally give them money, and they're usually devoted to a specific issue. So the WWF, for example, is devoted to organizing entertaining wrestling matches between pandas. Most NGOs are headquartered in developed countries. This matters, of course, when we talk about international influence, international relations, and international law, because it has a lot of important implications that these generally philanthropic, generally well-intentioned organizations are funded and controlled from developed countries, but often working in less developed areas. These are usually non-profit entities. Most NGOs in the world are purely domestic, but there are many international NGOs. And this brings us to this next kind of non-state actor, which are transnational networks and coalitions that bring NGOs together. NGOs in different countries with often the same intentions, for example, environmental protection or protecting wildlife, will often create networks and work together to promote shared goals or block things they think are bad. They can pressure both their various local governments to enact local laws, but they can also pressure lots of local governments, lots of their own countries' governments, to then sign on to create international treaties, sign on to existing international treaties, influence IGOs, intergovernmental organizations like the UN, to pursue various goals. So you can see why NGOs, both big international NGOs, can be important in international law, but also lots of domestic NGOs working towards the same goal. So, for example, the World Wildlife Fund partners with the UN Environmental Program to work towards protecting endangered species. Now, if we broaden this even further, we can talk about social movements more generally. And here, of course, Greta Thunberg is such a great example of this, right? Here's this 16, I think, when I'm recording this, year-old woman from a small Scandinavian country, but she's part of a much, much larger movement that's concerned about climate change. She, as a private citizen, has essentially no standing to implement anything to do with climate change from an international law perspective, and yet she's part of a movement that is having a lot of impact in ramping up regulation in dealing with climate change, much of which has an impact on international law. So, like a company or an NGO, these social movements usually start domestically but start to spread, create links across borders. And again, they usually don't have a formal place in international law, but they often lead to really important new developments in international law. The international campaign to ban landmines, as you might suspect from its name, was important in helping to ban, well, not completely, but is helping to restrict the use of landmines, for example. So, Much like social movements, experts and epistemic communities basically just means experts, scientists, professors, people that research and know things about things. They don't tend to have a formal place in international law, but like social movements, they can influence international law a great deal. So these can be experts from government agencies, research institutes, private industry, and universities. A lot of their work takes place at conferences and writing reports. So these might help publicize and give credibility to certain kinds of claims, like, say, about climate change or whether or not a species is endangered. They share knowledge through transnational networks. So not every country is necessarily going to have an expert on every subject, but they help share and transmit this knowledge. They help to frame issues. So a lot of times these expert epistemic communities might work with social movements, or social movements might kind of look to these communities for knowledge, for the way to frame certain kinds of issues. Framing is when we talk about how do you think about climate change? How do you interpret it? How do you understand it? How do you disseminate it to the public? But also, these communities would help propose specific solutions. How do we actually address climate change? What are the specific kinds of steps we can make? How do you calculate a carbon footprint of something? Right. So this is the kind of work experts and epistemic communities do. They're important, but again, and in some cases, just like a social movement or domestic NGOs, they can put pressure on their domestic governments to do things domestically, but also to implement either multilateral treaties or work through intergovernmental organizations like the UN. So moving on from what we usually think of as sort of well-intentioned non-state actors in international law, like NGOs, social movements, and experts, when we think about other kinds of non-state actors, we find that often international law doesn't work very well in applying to them, in regulating their behavior, and this especially comes in kind of a range of activities. So for multinational corporations, we find that international law often isn't very effective in nailing them down for tax purposes, or maybe in regulating environmental behavior, because if they can't dump their toxic waste in one country, they can go find another jurisdiction where they can do it, and often international law can't stop that kind of behavior. But from multinational corporations that are sort of looking for loopholes or lower tax rates, we then move to non-state actors that we might consider sort of more nefarious, but also similarly are able to use the fairly weak and low, the weak and not terribly punitive international legal system to get away with various activities like drug dealers and money launderers, financing of terrorists, gun running, human trafficking, and smuggling. So international law tends not to work very well with these things. So for example, terrorist finance, generally the United States has had to sort of unilaterally pursue financial organizations that it thinks are working with helping provide terrorist financing. So this doesn't mean necessarily giving money to terrorists, but say banks that are willing to work with organizations that support terrorists. Now the United States, because the dollar is still the most important currency in the world, the United States is still the largest economy in the world, more or less. The United States can often influence large financial institutions not to, say, work with organizations that help fund terrorists. However, again, this is largely the domestic law enacted by a superpower, not an international legal system that does a good job regulating this kind of behavior. So we think about gun running, human trafficking, smuggling, all these activities that tend to cross national boundaries. Even when they are regulated successfully, usually it's as a result of domestic and not international law. International law has to usually be designed very specifically to kinds of target these activities, and you usually need to come up with fairly novel enforcement mechanisms or work closely with countries that already have them and are interested in policing these kinds of activities. But still, non-state actors are really important when we think about international law and international relations more generally, because they can make up for weaknesses of a non-functioning state. They can help empower individuals, especially against a state bent on repressing them or a class of people, like a religious, ethnic, minority or gay people. They help defend against a dysfunctional states that don't work very well. International laws can provide some clear guidelines, some mechanisms to help push back against that. International law can help support and supplement a state, especially in areas where states may have not passed regulation yet, may not have thought about how to regulate new aspects of the internet. Maybe international law can help step in before domestic laws are completely ready to regulate these kinds of activities. International law also helps us find transnational solutions for transnational and global processes. So in an increasingly globalized world, a lot of our problems are global. And so non-state actors can be very helpful in helping to facilitate international legal solutions to global problems in ways that might be difficult for a state who has to face democratic elections, or who has to keep in mind primarily the interests of its own citizens. An organization that can look beyond the interests of any one state might be very helpful. And of course, organizations like NGOs especially can help ease the resource burdens, help provide development aid or environmental aid to countries that might lack those resources. So to wrap up, only sovereign states have full legal status in international law. Yet many people argue, despite this, that sovereign states are actually losing influence to non-state actors. And so I want you to think about three questions coming out of this. One is this true? Are sovereign nations really losing their status to non-state actors? Two, is this inevitable, or might this trend be reversed if it is true? And third, is this a good thing? Is it a good thing that sovereign states are starting to lose influence, if they truly are, to non-state actors? So these are just some questions to mull over as we go forward, and we think more about the specifics of how non-state actors might be involved in creating a treaty or regulating the way wars are waged, and the other roles we'll see them playing throughout this class. Thank you very much.